Welcome to this session on how to choose the right mediator. This video was recorded as part of International Mediation Awareness Week 2024. Before I go any further, I'd like to acknowledge the Aboriginal and Torres Strait Islander peoples as the traditional custodians of Australia and recognise their continued connection to the lands, waters and culture of this country. And I'd like to pay my respects to elders past, present and to emerging leaders. I come to you from the lands of the Gunai people in Victoria. I'm Joanne Law. I'm the Director of Mediation Institute, where we train accredited mediators, family dispute resolution practitioners, family group conference facilitators and some other specialty areas. I'm also the Director of the Australian Mediator and Dispute Resolution Accreditation Standards Board. So that's the AMDRAS board. It was formerly known as the National Mediator Accreditation System, the NMAS board, and we are in a bit of a transition period. So I will talk a little bit about that transition of accredited mediators. I'm also the Director of Interact Support and co-founder. So that's a social enterprise style not-for-profit that we established to provide mediation services for those that were slipping through the gaps in the current system. I'm a family dispute resolution practitioner, an accredited mediator, mentor, coach and trainer. What I've got to share with you today is a little bit about the different types of mediation. There are styles and approaches to dispute resolution, and also some of the styles and approaches to conflict resolution and how mediation can help, and some common questions. I have developed a little tool to help people with choosing a mediator. We can talk through some of the factors that will be on that, and I'll share that out via email afterwards. When I was looking for images for this presentation, when I'm searching for mediation, images with gavels and scales of justice, which are really the wrong principles for us. Mediation is a process that doesn't involve judgment. Regardless of the style of mediation, a mediator never has the ability to determine the outcome. We can't force an outcome. Our process is all about helping people to reach consensus, to reach an agreement. The picture would be fine as long as you get rid of the L's of justice and the gavel. That doesn't mean that we don't provide a fair and equitable process. It's just we're not going to do that judgment. And the other image that comes up is people having all-out arguments. Our obligations is to provide a safe process where people are able to communicate and discuss issues and hopefully resolve. Some of the key factors with mediation is that it does have a high resolution rate. It varies depending on the style of mediation and also what resolution means. And we'll look at some of the styles of mediation, but depending on the context, 70-80%, certainly significantly more than half of the matters that go to mediation result in an outcome that the parties have accepted and are ready to move forward with, either achieved during the mediation or shortly after in any little final bits of negotiation. It's a process that's safe and respectful. I think that photos of some student mediators, a student mediator who's not really up to the task, because we do see people look like they're staring daggers at each other. But we certainly need to maintain that. And it is a process of self-determination. In Australia, there are two types of qualified mediators. Accredited mediators under the AMDRAS system, formerly known as NEMAS or NMAS, and family dispute resolution practitioners. So I do want to have a quick look at those two types of mediation. So under the AMDRAS system, there are changes that are coming that may assist with choosing the right mediator for your situation. And here's a little image that I've created of the process. At the moment, all mediators, other than family dispute resolution practitioners, are accredited mediators. And what will be happening over the next months and year is that those that have got more experience and have been accredited for longer will have the ability to apply to become advanced mediators. and those that have been providing mediation for a long time will be able to apply to be recognised as leading mediators. There's also going to be a process to recognise mediators who also have specialisations. There are none at the moment. There's not been any formal application for specialisations, but that may come, and that may, again, it may be helpful in identifying a mediator who's got the specialist skills and knowledge that can support a particular situation. And thank you to everyone who's here, who are sharing who you are and where you are. It's great to see we've got some of our international friends here as well. So to know if someone's a nationally accredited mediator, they need to be on the register. If they're not on the register, they're not nationally accredited. What it provides to users of mediation, a guarantee that they've been trained to the standard, that they've passed a practical assessment, a role play assessment of their skills, that they have ethical standards that they need to comply with in terms of the work that they do as a mediator, and that they participate in ongoing professional development. So my point is, if someone claims to be a mediator in Australia and they're not on the register, you don't have any guarantees that they are actually trained, qualified and capable. With regards to family law mediation, they're mediators that have got additional qualifications and are registered to work in the family law context with the Australian Attorney General's Department. So it's a postgraduate qualification that they need to complete. And generally they'll have either experience in mediation or in the context, or they'll have a specific degree in law, social work, psychology, or dispute resolution. The critical aspect is that they will have done additional training in their obligations under the Family Law Act and the Family Dispute Resolution Practitioners regulations, which are specific regulations that control the role. If they're not a family dispute resolution practitioner, there's no guarantee that they have current understanding of family law, of family violence, and the best interest of the child's principles, particularly because there's been some very significant changes over the last few years. Our family courts have merged. There's been a very significant amendment, and there'll be another significant one coming in late this year or next year. There are mediators or people who claim to do family law mediation who don't have this registration. And part of my intention in this presentation is to really encourage not to engage with unqualified people for your family law mediation, for many reasons, but one of them is, if you do end up having to go to court for parenting matters, you'll have completely wasted your money, because you'll need to start again with a family dispute resolution practitioner in order for them to be able to, if they aren't able to help you reach a resolution, to issue a Section 60I certificate, which is needed to initiate family court action. It's always better to use the person who is qualified to do the work in the first place, and who also has the understanding of the context. Now, family law mediators, FDR practitioners, do provide some information and guidance in the family law context. Our approach and style of mediation is a little bit further down the spectrum, but here are 6 of the types of mediation that you might commonly find in Australia and potentially in other parts of the world. Settlement mediation or settlement conferencing, when it's done with an independent third-party facilitator, is very much around positional bargaining or negotiating a settlement to a defined issues in dispute. And sometimes that's used in family law, sometimes it's used in commercial disputes, contractual disputes and things like that, where it's really looking at trying to get that settlement. There is a form of mediation called expert advisory mediation, where it may be someone who's got some particular expertise in an area, maybe a construction dispute, and they have expertise around the issues that might arise in that context and the types of contracts. and they may give some opinions around the various positions. But again, if it's mediation, they don't have the ability to impose an outcome. Likewise with conciliation. So conciliation is a style of dispute resolution very much within the mediation range. And again, the conciliator will generally have some specialist knowledge about their particular legislation that they're working in. So Fair Work Commission, a whole lot of other government departments or instruments have a conciliation, sometimes they call it mediation, area that relates to that particular legislation. Moving down the spectrum, we've got interest-based negotiation, where it's much more around resolving the issues between the participants, and within the general obligations of human rights and legislative frameworks, it's much more facilitative. So the standard mediation form that's taught during the nationally accredited training is facilitative mediation, where the participants speak directly to each other and the mediator helps to facilitate an outcome. Problem-solving mediation is still around there, but it's much more around the strategies of trying to resolve a specific problem or the problems involved, and less perhaps on the relationship between the parties. And when we're talking about relationships, moving further along the spectrum is transformative mediation or transformative relationship mediation, which is sometimes used as an alternative to counselling or a precursor to counselling. This is a form of mediation that I'm familiar with providing, and it's very much around the relationship. It's not really about negotiating a specific agreement. The way I put it is renegotiating the relationship rules, and often something that might be appropriate after there's been a significant trauma or impact that's shaken up the way the relationship works. A narrative mediation, and sometimes mediation that's done in First Nations groups, is much more around the story and being able to get the story out in a much more holistic way than is typically the case in a mediation. If anyone here has different types of or styles of mediation that you've identified, please use the chat to share. There are some areas like elder mediation or elder care mediation, which might be between family members and including or perhaps not including the elder in the family whose perhaps capacity is diminished to a point where there needs to be an agreement reached around how they might be cared for. That's an area, but it generally falls within these facilitative or problem-solving. I'm not sure, if you're on a small screen, you're probably not able to see this at all, but it's just showing that outside this scope of those 6 types of mediation, there's further areas where you might have lawyer negotiations where there's no independent third party and it's direct negotiation with lawyers involved. Often it's done by letters and offers and proposals, and then if things can't be resolved, it's going to end up in a court or tribunal, or potentially, depending on the context, it might end up in arbitration. On the other end, there's things like family group conferencing, where the facilitator brings the family together, but they don't facilitate as hands-on. Generally, they'll create the environment, allow the information to be shared, and then leave the family to come up with a plan. And that's often used in child protection, out-of-home care, and those sorts of situations. And allied to that, but in a different context, is group facilitation, where we might use our skills as a mediator to facilitate group discussion. This is common in workplaces or organisations. Again, maybe bringing in a little bit of the narrative, allowing people to have their say and then move forward. And then you've got restorative practice, which is generally done in context where a harm has been caused and it's been acknowledged either by criminal charges or other means. And the restorative practice is a way of trying to build understanding and bridge a path forward. Very brief overview on those aspects. One of the biggest challenges we have as mediators is that people think, well, how could it possibly work? You know, all you're doing, you're getting people together, you're giving them a chance to talk, how on earth could mediation possibly work? And this model, which is based on a conflict approaches model that's probably, it's been around since the early 70s. So it's a very common model. And it's not to say that any of these approaches are inherently wrong or inappropriate. They're all appropriate in a certain circumstance. But if we're going to get an agreement in mediation, which has to be voluntary, because we have no ability to force someone to agree, we have to get people that perhaps are not feeling that way into a mindset where they're willing to either compromise or potentially find a way that they can collaborate with each other for an outcome that's beneficial for all people involved. So I do want to spend a little moment having a look at this. So for anyone who isn't familiar with this model, on this axis we've got assertiveness. So how focused the person is on winning. So if someone's avoidant, they're not focused at all on getting an outcome. They're focused on getting away. It's fairly common if people feel like they haven't got enough power. It's also very common if people have been exposed to violence or abuse or things like that. So they feel like there's no point in them raising what's important to them because who's going to care, who's going to listen, or maybe it'll be even worse, it'll be used against them. So as a mediator, our process, which I explained about before, it's got to be safe, it's got to be, our ethics require that we make it equitable and we really work on helping people to express their needs and interests. Interest means what's really important to them. And by doing that, we raise people not up to being competing, but up to being able to work out what's important, what would be suitable for them for an agreement, what they can accept. Likewise, a really common approach that we see as mediators is a competing approach. And this is often the approach that's used in lawyer negotiation, for example, where the lawyers are working as hard as they can to try and get the best outcome for their client. The problem is, it's a power-based approach where someone may win and someone else may lose. In mediation, that's not going to work unless the mediator's not done their job and they've allowed abuse to occur, because who's going to voluntarily sign an agreement where they're completely losing? So our job as a mediator is to help people that are just focused on their own outcomes to realise that unless they listen to the other person and think about what it is that's important to them, they're not going to get anywhere. And they'll have to try their luck with a more expensive and less certain process. Because one of the big benefits for mediation is if you can reach an agreement, you've got the certainty. It's agreed and it's done. So compromise, I think everyone has an idea of what compromise is. You give away some things that are less important to you in order to get some of the things that are really important to you. And our job as a mediator is to help people to actually get clear on that. Because if people haven't got much experience with negotiation, and people that are used to steamrolling their way through and people that are used to running away often don't have very good negotiation skills, our role is to try and help them to really think about what it is that's important. Now, the other approach that doesn't really fit that well in mediation is the accommodating approach. They're engaging, but they're trying to focus on the relationship, focus on the needs of others to the extent that they're not articulating what they need. And you actually may quite easily get an agreement, but eventually they're going to realise that it's what they've agreed is not appropriate. Perhaps they'll renege, they'll go back on what they've said they'll agree, and it's going to be a little bit of a waste of time, or it may be of process. So you've got someone who agrees to things that they shouldn't, that are much, much worse than they would be if they used another approach. And one of the things that we do as mediators is we ask people about their alternatives to reaching an agreement in mediation. And sometimes that sort of reality testing of helping people to look at the bigger picture can really help them to shift from just being accommodating to actually expressing what they need, as well as considering what the other person needs. So I spent a little bit of time on this model because I think it's really important for anyone, whether you're a mediator or you're using mediation, to really think about how people are presenting and what might need to change for them to get to this point where they can reach a mutually acceptable agreement. I will go through a couple of examples and then open up for discussion. Hopefully we'll have a little bit of time for that. So here's an example of workplace, which is a really common area that mediation is used. So what can happen in workplace? There might be a facilitated discussion. So let's say there's been an argument in a meeting, someone said something that's really upset someone else, and it's led to an inability for people to work together. A facilitated discussion, it can be facilitated by a mediator, but often it's not. It may not be confidential, and the person that's facilitating it may not be independent. It's really important, if you are in a workplace context and someone's saying, oh, you need to come in and have a discussion about this, that you ask some questions about, well, who's going to be facilitating it? What's their role? What's their connections with the other people? Sometimes that facilitated discussion can be a perfectly appropriate process, but it's really important to be clear about what's going to be done with information that's shared. Is it going to be confidential? Is it going to be used in certain ways? So that you know what's appropriate for you in terms of participation. Mediation, again, sometimes people say something is mediation, but the person isn't a qualified mediator. My encouragement is always to ask, don't just assume, because it may be someone who does have a conflict of interest, who perhaps has an agenda that they're trying to achieve through a process they're calling mediation. If it's mediation, it's going to be confidential, and the mediator is going to be independent of any of the participants in the process. In this context, in workplace, sometimes there may be, it's not fully confidential. Often there's going to be information shared, such as, did you attend? If you attended, sometimes what was the agenda? What were the issues that were discussed? And sometimes the agreement that's reached, there's an agreement for that to be shared back to the workplace, who's usually paying for the mediation. The mediator, if they're a professional mediator, they won't be doing a debrief of what happened in the mediation, and they definitely won't be making any reports or recommendations other than what's been agreed with the parties. Sometimes in workplace, what happens actually before mediation is an investigation. That's really around determining whether claims that are being made are true. If it's an investigation, it's not confidential, and there will be a report and there will be recommendations. So it's really important. That should be clearly articulated to you, but if not, make sure that you are aware of what an investigation is and if it can't be resolved. And sometimes workplaces bypass mediation, maybe they do a bit of an investigation and then they end up straight into Fair Work or some other tribunal, and that will be a process of conciliation. So there'll be a mediation type event where there's an effort to get an outcome, and if not, then it'll need to be determined. With that conciliation, as I mentioned before, generally the conciliator will be making some recommendations or identifying how the legislation may or may not have been followed. Sometimes there might be a group facilitation as well. If the conflict's been allowed to go on for a long period of time, you'll end up with factions, and people automatically start looking for allies when they get in conflict, rather. So there's often a need for a wider intervention. The next area I wanted to look a little bit deeper in is family conflict. And again, as you'll see, there's a lot more complexity there. I will share a link to this presentation because I'm aware if you're on a small device, you won't see any of this. And I'm not going to go through in fine detail. But generally, with family dispute resolution practice, we do bring in other specialists. We generally would want people to get legal advice so they understand the context that they're in and their rights and obligations under family law. Sometimes we might refer them to financial advice, financial counselling, to talk to a broker or a bank about their borrowing capacity if we're doing financial negotiations or mediating for a property settlement, getting valuations. So there's a whole lot of additional work that we help people to do, send them to do. We don't do the work. If they've got superannuation, we might send them to get a valuation. If it's a self-managed fund or a defined benefit superannuation, then that's going to be needed to be valued before we know what the amounts are. With children, they may be involved in the process by visiting or spending time with a child inclusive practitioner who meets with the child and then brings their voice back into the mediation. There is one approach where it's the mediator that meets with the child and then brings that back. So there's a few different variations on how that can happen. In any sort of mediation, the FDR practitioner should be child informed. So we should understand, for example, the impacts of exposure to conflict to children and advise, really tell the parents about the harm that they're causing, like to this poor little fellow that's stuck there in the middle of his parents arguing. Again, there are other processes other than family dispute resolution, which might be lawyer negotiation, again, without that independent third party. There's a process called collaborative family law, which tends to be fairly expensive because the lawyers are involved, both lawyers all the time in every stage, but its purpose is to keep people out of court. So it's very much focused on helping to negotiate an outcome. Family law arbitration's available, but generally only with property, and that's like getting a private judge. So it's a way to get an outcome much quicker than going through the court process, and it leads to a binding arbitration agreement. Very much underutilised in this context, but certainly available. And then ultimately, if people can't reach an agreement, they don't just give up and live with the conflict, which I'm not advocating for at all. They may end up in family court, which is either the Federal Circuit and Family Court of Australia or the Family Court of Western Australia. And when they get to court, they're usually going to be ordered back to mediation or lawyer negotiation along the way until there's some sort of an agreement that can be handed up as court orders. Very, very few matters in our family courts end up as a final hearing. Generally, there'll be some sort of settlement negotiated along the way. So there are some other approaches like transformative relationship mediation, which can help if people are in a relationship or might be other family relationships and they're wanting to try and sort things out. There's counselling, which is often encouraged as people are going through these sorts of processes, as well as courses and coaching and classes. So there's lots of support that can be provided other than mediation. What I was trying to show here is that mediation fits within the realm of a whole lot of other professionals who can help people to resolve their disputes and conflict without resorting to violence, and hopefully in a way that's as equitable as it can be considering the circumstances. I haven't gone into violence in this presentation, but it is a major issue in Australia, particularly in this family context, and something that one of the reasons that I do recommend that you should only be working with a family dispute resolution practitioner who has qualifications and obligations in regards to ensuring that the process is equitable and that people aren't coerced into an agreement. I had a couple of questions that were put to me that I was going to address. One of them is this assumption that lawyers are already skilled in mediation. In their legal training, they have minimal or no real training in mediation without doing additional studies. And the role that they have as lawyers, we've already had a look at, is competing. So they're to try and represent the best interests of their client. So generally, most lawyers are really aware of mediation and supportive of it, and generally will be encouraging their clients to try mediation first. However, if your lawyer is actively discouraging mediation or indicating, it never works, or any of those sorts of things, one of the things to think about is what's the benefit that they get from you engaging in a more expensive, more adversarial process. There is the direct financial benefit. It's only a minority of lawyers that would behave in this way, but generally, if mediation's possible, perhaps with the support of your lawyers and other professionals, it's usually going to give a better and more effective outcome than more adversarial process. This is the checklist information that I was encouraging you to have a think about. Number one, is the mediator qualified and accredited, either as an FDR mediator or AMDRAS accredited. Now, for those in other countries, you may not. I know that in Kenya, you have an accreditation system through the courts, so the same thing applies. Is your mediator trained and accredited? Other countries, it's a little bit less certain, so you might need to rely on the information that the mediator provides and perhaps an interview with them to get a feeling for the type of work that they do. So the type of dispute that you're doing, it's important to get a mediator that has some understanding of the context of your mediation. Again, that's something to find out from the mediator or from the panel of mediators that you're offered. What areas do they have expertise in? If we're looking at facilitative mediation, generally the mediator is facilitating you exchanging information about your circumstances. Certainly if you're wanting a more evaluative type process, then the mediator's solid and current is really, really important. The mediator's styles. What's going to be more appropriate for you and the other party in the matter in terms of approach? Do you want someone who is more on that transformative therapeutic end of the spectrum, or are you looking for someone who's really straight down the line, looking at the black and white letter of the law? Cost and availability. So there isn't always a direct relationship between cost and quality. Some services will be subsidised, some will be provided by volunteer mediators. Even at some of the community legal services, they now have mediation practices. There's some not-for-profits providing services, and ultimately the comparison, though, is having a think about what the cost of mediation compared to the cost of alternative processes, such as that long-term legal negotiation or court costs. Trauma-informed. So if there are issues around trauma or violence, is the mediator qualified in those areas? Do they have an understanding of the impacts and consequences of those sorts of life events, and are they able to manage that? Logistics. Is face-to-face important? Is face-to-face not wanted? Do you need a mediator that's in your local area, or doesn't it matter at all? They're all considerations. And then reputation, recommendations and information. Generally, mediators won't ask clients to provide public recommendations. It depends on the context, because our process is confidential. We're not wanting to publicise that they've needed to use mediation. However, some may approve of private sharing of that sort of information. A general reputation, information that your mediator might be sharing out on social media and other areas where you're able to get a feel for what they do. They should have a mediator's CV or other information which will give you a little bit of background information. Generally, you're able to contact their professional association, or maybe there's panels or directories that they're on that will provide a bit more of that background. I've got a little handout sheet that I can provide you so that you can use that as an evaluation tool. And this might be useful for lawyers and other advisors that are referring people to mediation to, I guess, have that understanding that there are a whole lot of different styles and approaches that mediators have. Just responding to a question from Phyllis. FDRP, that means Family Dispute Resolution Practitioner, and in Australia, that's a role that's registered through the Australian Attorney General's Department. So thank you. I will stop the share there, but if anyone has any questions or comments that you'd like on recording, then please ask them now. If not, I'll stop the recording and we can then talk about them.